Ladies and gentlemen, good morning to this side event on climate-related dispute resolution, resolving climate change outside of state courts. Yeah, I think, at least for me, it's a very interesting topic, and my people, my PhD, I hope also for you. As you are aware, climate litigation is really on its rise. And myself, I underestimated when a doctoral student asked some years ago whether he can make his PhD on climate litigation. I said, really, must that be? Now I'm convinced through him and through what we have in practice. And climate litigation is not only a device for justice, it is an instrument to push and forward climate policies. It has a tremendous impact. Now, today we will not talk about climate litigation. We will talk about other things combined with it, and they are not yet enough in the focus. First, we will talk about climate arbitration. Wherever you have litigation, you should also offer arbitration. We will explain which is more flexible, has more options, possibilities than state courts. So I think climate arbitration is done now by the big arbitration courts for investment, for energy, and so on. And what I will argue today is we need a climate arbitration court. And I have already ideas if you want to ask me later on. Again, climate arbitration and litigation necessarily are combined with mediation as a much more stronger and third way, because mediation is not about just finding compromises between two who have a dispute. No, mediation looks into the interest of these people, and from there it can elaborate maybe much better solutions than litigation and arbitration can. Yeah, and finally, communication. All this litigation, arbitration, mediation goes through language. And the progress in communication, specific climate communication, will open even further options. So I'm very happy that I have such a great panel today sitting here with really fantastic institutions, Mediators Beyond Borders International with Christine Peringer and Joe Siegel, and International Environmental Communication Association with Miriam Kelly and Gregg Walker. So to myself, I'm a lawyer and political scientist and professor at the University of Greifswald. This is a tiny little town in the north of Germany, but one of the oldest universities of Northern Europe. I'm heading there the cluster energy of the Interdisciplinary Research Institute for Baltic Sea Research. And finally, I am director of the institute ICEM, Institute for Climate Change, Energy and Mobility. In a nutshell, we are dealing with the law and policy framework of climate change and energy transition. So now to the first round of speakers. First, we go into arbitration, and afterwards we have a block for mediation and for another block for communication. Yeah, I'm happy to introduce to you now Greta Reh. Greta Reh has a PhD on United Nations human rights, so she has worked for the United Nations Human Rights Committee, and she is heading at ECIM, our research academy, which is more the part who's dealing with the basic fundamental research. And she is now editing the first and only German-speaking journal, Klima und Recht, Climate and Law. So, Greta, the floor is yours.
Thank you. I know I'm standing here in a pink suit. Don't let that fool you. I am a German lawyer, and I will do nothing today to get rid of that dusty image you will have of a German lawyer because, well, as my colleague said, we have very interesting people here today who will talk about very interesting and very specific cases, which is why I today chose to just give you like the basics of a few key words we will be using today so that you're not sitting here completely lost thinking, I'm not a lawyer, I can't follow this, and I want you to all be able to fully enjoy these other speakers. So I'm afraid I will be a bit a German lawyer. So the key words I will be discussing today are what is a climate dispute, what do we mean by that? Then what is arbitration? Also, what in comparison to that is mediation? And then of course, what are general advantages and disadvantages of these procedures, but also what are specific advantages and disadvantages of climate-related disputes in these out-of-court procedures. So, starting with climate dispute. As we've already heard, climate legal action is increasingly becoming a thing. And it is an instrument of general climate protection that always goes beyond the specific case. Now, climate change, of course, affects all areas of our life, and so it will also affect all areas of law. That is national, international, private, public, constitutional, administrative, human rights, you name it. So by climate disputes, we simply mean any dispute that might be related, even just narrowly related, to climate change. So this could relate, for example, to prevention, to technical standards, to adaptation, and of course, to compensation. Potential cases might include, to just name a few and give you an idea, competition disputes between two companies regarding climate standards of products or supply chain and their agreed climate standards. So an example of that would be like Company A claims that their products are climate neutral and their competing company doubts that. Of course, similar disputes then might arise between individuals or NGOs and such companies. Another potential case might be disputes between states based on agreed climate commitments such as the Paris Agreement. There could also be citizen-state disputes. I think you can all think of some that have already been discussed based on either binding climate-related obligations or even obligations that are only de facto climate relevant, such as, for example, investments. Now, moving on, what does arbitration mean? Arbitration procedures might be the most well-known form of out-of-court dispute resolution. Arbitration courts are not state-based, their arbitrators are not judges, but they are experts that were chosen by the normally two conflict parties. In fact, everything about arbitration is chosen by these parties. That is the place, the rules of procedure, the exact scope and limits of what shall be the outcome and what will be decided. This is why the decision that is then taken by the arbitrator or the arbitrators will be binding because the parties have priorly agreed on that. That also means that then this arbitration decision will not be overruled by a state or international court decision because it is no longer subject to that jurisdiction. What are general advantages or disadvantages of arbitration courts? Obviously, a huge advantage is acceleration of proceedings. Therefore, also, they might be very cost effective because you don't have to go through like a normal state procedure that might take you months for a court even to tell you whether they take on your case or not. Another huge plus point is flexibility because you're the ones who decide what exactly is the scope of what you want to be discussed and also what you want the outcome to be. Traditionally, these decisions or the whole procedure actually is also confidential, which especially for company-company disputes might be a plus. And then, of course, the expertise of the chosen arbitrators, as the parties are the ones that choose who is going to rule over their dispute. They might also choose somebody who is very specifically educated in that very little narrow problem they're discussing. What are some disadvantages? Well, the arbitrators, as I said, are not judges. That also means that they don't really have the same powers of judges, like ordering access to documents or ordering witnesses. They can't do that. Also, the outcome will, as I said, be very case-specific. That might also have negative impacts, of course. As I said, the decision of an arbitration is binding. That means no legal remedies. And finally, as arbitrators are not judges, they also don't have to be neutral. I'm now coming to mediation. What is mediation? Generally speaking, it's a confidential procedure in which two parties seek to resolve a conflict with a mediator, very simple. The aim is usually not to resolve a legal problem and to achieve general findings, but rather to find an agreeable solution in a conflict of interest. That might also be a very emotional conflict, where it is not about finding a winner-loser situation, but rather just finding out what the parties actually want and what they can agree on with the help of a mediator. So that also means that the parties will decide on whether the outcome of this will actually have any legally binding function or not. We will later hear some great example of climate mediation. So now I'll just give you some ideas of what that means for climate arbitration or climate mediation. What are general positive and negative sides on that? So the acceleration of procedures is, of course, a huge thing. We are all here discussing every day how pressing the climate change issue is, how fast we need solutions, and we've all seen climate litigation, like in our home countries, NGOs or private people trying to go to court, and it just takes years and years. In arbitration and mediation, this might be much quicker, we might have solutions much faster, and that is something we do need, absolutely. Also, of course, the very specific expertise of mediators or arbitrators. So we've often seen that in climate change-related litigation, you will have a judge that is not specifically educated in any of the very complex scientific backgrounds they might need to actually rule on what they're deciding on, because it's not only a matter of law, but also a matter of understanding the scientific background. That might be a very big plus for when you choose an educated arbitrator. And then, of course, the outcome is also more flexible. So it is often not about like finding a winner or loser, but rather finding a common solution. There are, of course, also negative sides to arbitration and mediation. I will mention them. So first of all, many of these situations will not actually be pressable into two-person conflicts. That's just not how climate change affects us. So it will absolutely not be applicable to any climate change-related conflict we might have. Also, the traditional confidentiality of procedures means less public awareness. We have often seen, especially NGOs, going to a court not so much for the outcome, but rather for the press, for being seen, or being able to talk about why they're litigating. And that might not be as easily possible in an arbitration procedure. Also, an advantage of classic state courts or an international court might be that the outcome is more general and less case-specific, so applicable to other cases as well. So I conclude that arbitration and mediation are important, they are definitely on the rise, but they will not and they should not replace litigation. I will already come to an end because we have so many more interesting people here. who are not lawyers. So I think what we will show today is that climate change-related arbitration and mediation are just as well on the rise as we have seen in climate litigation. What you all might take away today from this discussion is, should we advocate for a stronger development of these out-of-court proceedings? Do we then maybe need a specialized international court for that? And also, how can we learn from different regions of the world and their already very lively practice on that right now? So I'm very excited to hear from Maria about the developments in Brazil. Thank you.
Thank you very much, Greta. I will, that you stick also to the time frame so well, this will allow me, after Maria, as a second lawyer, to give you the opportunity to one or two questions to our lawyers. I'm very happy to have Maria here on the panel again, because this was the case 3 years ago at the COP in Madrid. Maria Rulim has worked for more than 20 years in the field of energy law and is widely acknowledged as an expert in regulatory renewable issues, currently president of the Brazilian Bar Association's Energy Special Commission in Sao Paulo and Minas Gerais. She holds a PhD from the Center for Energy, Petroleum and Mineral Law and Policy of Dundee University in European law, from the London School of Economics, and an LLM in economic law from the Federal University of Minas Gerais, and some others which I skipped to have more content. Maria, the floor is yours.
Thank you, Professor. Good morning, everyone. It is a pleasure to be here. Good morning, everyone in the table as well. Well, as Greta said, it is a new way of looking to litigation or out of litigation, a way to sort it out, and we are trying to explore how we can solve disputes in out of the court and if it is suitable or not, or more or less, for climate change related issues. Well, I'll bring you, well, let me see, here is here. Yeah. Well, first let's talk about a little bit, explore a little bit more what are the potential use of arbitration in climate change. I think Greta said enough already, said a lot already, but I want to explore a little bit more in terms of contracts. So disputes involve commercial contracts concerning energy, land use, urban infrastructure. All of them are suitable to discuss in arbitration as well. Special contracts, you can have different types of contracts. You can have contracts related to implementation systems and transitions and the mitigation or adaptation projects linked to the Paris Agreement. But you also can have contracts without any specific climate-related purpose, but where a dispute gives rise to climate-related issues. It's not to implement something on Paris Agreement or the UNFCCC, but during the proceedings you have some climate-related issue arising. And you have also submissions or other specific agreements that people enter to, parties enter to solve existing climate change damages or disputes or involve impacted groups or populations as well. In Brazil, we had, unfortunately, several examples past years in Samarco and in Mariana. We had so many problems that now we are trying to sort it out, some of them out of the courts. And also disputes involve international investment would tend to increase because of the Paris Agreement combined joint mechanism to implant projects and for countries to meet their NDCs. About Brazil a little bit, we have a legal frame and some restrictions and some possibilities to work with them. Our constitution says that environmental restoration is a diffuse right for all the citizens, so it's not transferable, disposable. So it would be difficult to go to the court, to go to arbitration, to discuss, for instance, that the state or someone has to restore the environment or a river or what so on. But our arbitration law says that any person or those who are capable of enter into contracts may make use of arbitration to resolve conflicts regarding freely transferable property rights. So we may not be able to discuss when a population requires to the state to sort it out something related to the environment. But we have contracts between the companies in investment and so on, where something or the default has the climate change issue related to discuss. So patrimonial repercussions on environmental damage for individuals considered and who are directly or indirectly harmed they are disposable or transferable rights, so they are up to compensation for damage, so they can go to arbitration to discuss this damage and compensation. And contracts in general can be sorted out by dispute related to contracts, can go to arbitration. Some case or some news from Brazil that I think might be interesting to arbitration. First of them is a recent decision before our Supreme Court that is related to Amazonia Climate Fund. But the good thing or the reason or the main reason of that is because our Supreme Court just said that the Paris Agreement has this supranational effect, which means that it is for us like our constitution, and you can invoke them directly through as a constitutional norm. So it might be good for climate change, but it is also climate change fight, but it is also makes the country more exposed to climate change litigation, of course. We have another one that it is an old one. Itaipu is a reservoir, a big power plant, and local communities, when it was being built, actually, said they entered into they came before our courts, a local court, a national court, to discuss that the reservoir would impact the local climate. At that time, in 1980-something, it was not considered a climate change litigation. But if it were today, I'm sure it would be. And it is the kind of thing that could be sorted out in an arbitration, because they were asking for damages, because it would impact their way of living, and which is basic agriculture. Today, it is already pending decision, but the company, the Itaipu, had to implant loads of stations to check if the climate was being changed, was altered, and if it was because of the reservoir or not. Nowadays, they decided to keep the stations there because they never know if someone can come and say, invoke something like that. And during the shortage, we have a shortage of water last year in Brazil and the year before as well. And our electricity depends on hydropower a lot. It's 62% around, more or less. It used to be 90% on hydropower. Nowadays, it's around 62% of hydro. And because of the shortage of the water, we had to kind of hold water in the reservoirs to save water, actually, and it impacted the navigation and other activities around the river. So they are before our national court asking for damage. The communities or even companies that depend on using the river or the water are suing the transmission operator system because the decision of saving the water came from the transmission system operator. So it would be another case, because they are asking for damage, that we could negotiate over arbitration case. And finally, I just bring some points to consider. This international dimension of climate change might be, probably will be increase the presence of states as parties as well, or in international arbitration, being a suitable forum, but also the use and of the resource to appropriate scientific and other expertise. I think it's something to bear in mind that arbitrations, they are experts, so it might be good for the dispute and quicker to have someone that understands proper the effects of climate change, not only contract law, but contract law is one part of the dispute. The other part is to understand how these climate change effects may affect or not the contract, force majeure and other provisions that we have to look at and see if it was predictable or not, if it was inside the risk analysis of the company or not, if it should be or not should be. The procedures also provide for early resolution of disputes or urgent interim or conservatory relief, which means that, as Greta said, we cannot, as arbitrators, we cannot order or demanding things like the judiciary, but you can act together with the judiciary to get some interim measures or some provisional measures while you are discussing the arbitration. And the good thing, the best thing I think, in my opinion, is this possibility to integrate climate change commitments and the principles of international law with the UNFCCC and Paris Agreement framework, legal framework that is already in place. Nowadays, we already speak about independent discipline of climate change law, which might be one of, and it is funny, I forgot, because it's more or less the same way that environmental law emerged. It was a kind of a multidisciplinary view that nowadays we understand as a structured and independent discipline in law. And that's all, actually, that I have for you, and thank you very much, and looking forward to the discussion.
Thank you very much, Maria. Also, you stuck very well to the time frame. In the end, this is I'm heading for, to give the floor opportunity for discussion. But I also now, after the first block, if you want to ask something very specific to these legal aspects, so if you are challenged, like being a lawyer, for example, or a law student, you could also raise your hand right now. Otherwise, prepare for the general discussion. Okay, so we go on then to the mediation block, leaving the law block of litigation and arbitration. And I'm, as I said, very happy to have the organization Mediators Beyond Borders International here, and Christine Peringer and Joe Siegel especially. So let me introduce them shortly. Christine is a facilitator, mediator, collaboration coach, and communications trainer, specializing in multi-stakeholder planning, negotiation, and consensus building processes. Before working as a facilitator and collaboration consultant, she had leadership positions in several non-profit organizations. She holds a Bachelor of Laws from Osgood Hall Law School and a BA in English from the University of Western Ontario. And Joe, who will follow right afterwards, they deal with their slots themselves. He teaches environmental dispute resolution at Hofstra Law School and climate change and resilience at Hope School of Law at Pace University. He's an environmental conflict resolution consultant, also facilitator and mediator. In addition, Joe manages the Environmental Collaboration and Conflict Resolution Program in the United States Environmental Protection Agency, New York Regional Office. He is also a member of both Mediators Beyond Borders International, as such today, a climate change team leading the group Education and Outreach Subcommittee, and the UN multilateral working group. So I'm very impressed and happy to have you here, and now start with your slot on mediation.
Thank you, Michael. And let me just clarify that I'm not here in any capacity with the U.S. government. I'm on vacation time to be at this COP, to be here on behalf of Mediators Beyond Borders International. And Christine and I will be a bit of a tag team on this block. I'll start off by talking a little bit about just generalities on mediation and then climate change mediation. So, like arbitration and court decisions out of judges, we use an impartial third party as a mediator to resolve disputes in mediation. The difference is that, unlike arbitration and court decisions, the mediator does not render a decision. Rather, the mediator helps the parties to come up with a mutually agreeable solution themselves that will address the interests of the parties. Mediation is voluntary, generally. Parties can withdraw at any time from a mediation. Now, we do see courts ordering mediation, and even in those cases, the parties may be required to attend 1 or 2 sessions in good faith, but after that, they can withdraw from the mediation. I see mediation as an advanced settlement tool. It's really assisted negotiation. A key element of it is confidentiality, because parties will not feel free to share information with the mediator unless they know what they're sharing will be held confidential. Types of disputes. You've probably seen mediation used in many contexts: family disputes, labor disputes, contract disputes, but it's also used in environmental disputes quite a bit. And we're starting to see it in climate change disputes as well. We see mediation used in all kinds of venues. So governments suing governments, governments suing private parties, business-to-business lawsuits, NGOs suing government. You can see mediation used in all of those contexts, and you'll see it in the courts, but you'll also see it outside the courts, where parties hire a mediator sometimes before they bring a lawsuit, and other times after they have brought a lawsuit, they will hire a mediator outside the court system. Likewise, mediation is used in administrative tribunals as well. I'll give you one example of mediation being used for a climate change related matter, and that is after Hurricane Sandy hit the east coast of New York, east coast of the United States, with particular impacts on New Jersey and New York, there were a lot of insurance disputes due to wind damage and water damage to homeowners and businesses. In only one federal district court in New York, there were 1,440 insurance cases filed soon after Hurricane Sandy. So that court set up the Sandy mediation program, and 2 magistrate judges and an ADR administrator did a study of that. They concluded that of those 1,440 cases, nearly half of them were sent into the mediation program, and 27% were settled even before the first formal session. Of the ones that went into formal session, the settlement rate was as high as 75%. As of 2021, the United Nations Environment Program identified 2,100 environmental courts and tribunals throughout the world in 67 countries. That presents tremendous opportunity for using mediation through the court and tribunal system, and I'll give you one example. The first environmental court that was established in the United States was in the state of Vermont in 1990. They have a robust mediation program, an environmental mediation program with a roster of mediators who are specifically skilled in environmental mediation. According to the UNEP report, 1/3 of their cases are referred to mediation, and of those that are referred, 75% of them are settled. I'll turn it over to Christine. We'll be a tag team, and I'll be back in a moment.
Good morning, or I guess we're just into afternoon now. Good afternoon. I'm going to talk about multi-party facilitation. If you were to imagine a continuum that at this end you were in court with litigation, and then you move along to have arbitration, and then you have mediation, the next spot along you would get to would be facilitation. And multi-party facilitation is a neutral-led process that makes decision-making easier, more enjoyable, more productive for a group. So this immediately addresses one of the problems identified earlier about mediation normally being between two people. This is a process explicitly designed to deal with multiple parties. And it is used when there could be, I had trouble writing this slide, there could be between 30, I wrote down 1,000, went back to 3. I've even done facilitation with a single person. And I don't know, you've probably experienced it, that within yourself, you've got all these different views on something and you need to have them come together in order to take action. So I even could have put down 1 down there, but that would have taken us more into psychology and away from the focus of today. It's used also when a decision or other product is needed. So this distinguishes it from just moderation or facilitated knowledge exchange. Those are other times when we use facilitation. But multi-party facilitation is when there's a pressing need for something and you need each other to do it. And often it is characterized by either complexity or distrust between parties. So complexity is when a client might approach me and say, we want to get the views of the whole community and we want them to come together. We've got 4 sub-communities within it. Our room is only big enough for 30 people. How do you propose we do that? So they'll come to a multi-party facilitator in order to help develop an iterative process for consulting the larger, bringing that in, and coming closer so that a smaller group can actually move forward informed by the whole. It's also needed when all perspectives are needed for optimal implementation. This is almost always the case when you are trying to implement some kind of policy. You need to identify who all the stakeholders are in the success of this and bring them together. But there are some decisions where you don't need all the parties. So there's a discernment process about when you need a multi-party facilitated process and when you might need just an advice process or some other way of moving forward. Whoops. Oh, I am trying to move. There we are. So sometimes people are frightened by multi-party facilitation, and the response often is, oh my goodness, all these different views, how can we ever move forward? Isn't it easier to just make a decision and hope it works out, or get a few opinions and then make the decision ourselves? I'm thinking about a government or some other group that needs to make a decision. And so this is when a facilitator would show this diagram where it identifies that there's an important period of identifying what the problem is, and then allowing a divergence of discussion about what possible solutions might be. And then in that middle, that's off where that dotted line is, sometimes called the groan zone, because it's the maximum chaos and the minimum sense of how this could ever be resolved. And I see nodding going on among you as I say that. And this is when a facilitator will have a whole number of tools in order to assist in the ordering of this and seeing it all as fertile ground rather than a problem. And then from that fertile ground will start to emerge thematic areas. And then each will need to be attended to, often using a similar process of identifying people to work on that subunit, but sometimes by quite different processes. Some of the aspects might need more consultation, some might need more scientific information. Each will have its own trajectory, and then things will gradually converge. And then towards the end of this, you start working on a process that looks like the process that happens in negotiations here, where you have a unified text with brackets around the bits that you're not sure about, and you just work through them slowly together and carefully. And again, checking back with stakeholder organizations and coming forward. Often these processes can take 6 months to a year in order to come to a robust decision. Fundamental considerations when doing this work, we call them the 3 Ps. You need absolute clarity on your purpose and work early on with stakeholders to articulate it simply, just in a few words, so that anybody can say at any moment what you're all doing together. There's nothing like a room full of people and everybody thinking that you're doing slightly a different thing. And this might even evolve over the course of the first few meetings and another thing on purpose is just to make sure as a facilitator that it is presented perhaps from different directions, maybe more creatively sometime, maybe in a song, maybe in something else, but keep that in front of the parties at all times, because that is your North Star. And then there's a careful consideration of people. And my colleague Mariah Kelly from the International Environmental Communications Association will be addressing this in more detail. But fundamentally, who are the in-room and beyond-room stakeholders? And what are their needs to contribute to the achievement of the purpose you've identified? And what is their potential impact on its success? And finally, after those things are kind of clear, then you move into the process. And there you'll collectively develop understandings and agreements on roles and responsibilities within the process. This is essential because it sorts out actual and perceived power within the group, a really important consideration. Vocabulary, what you're going to call the key elements, because when different sectors come together, they sometimes have different names for things. And if they're all using their own vocabulary, they can start to annoy each other, and people can feel that your term for that is being imposed on us, rather than come to collective agreement about how you're going to label things. A decision-making process. Multi-party facilitation often uses a consensus decision-making. Sometimes and regularly it will have some clause that if consensus cannot be reached after all opinions have been thoroughly heard, understood, and considered, then there may be a process of going to some kind of weighted voting system that if 75% of the people agree, then you'll be able to have a decision. Often, though, it can't be about something that's very fundamental to the process, or else it won't work. Because that's why you've got all the parties together, is because it's been identified that they're all needed for the success of the implementation of whatever the agreement is you're coming to. And finally, just clarity about other enablers and constraints like time and funding and other such considerations. So I'm going to pass the microphone back to my colleague Joe now. Thank you.
Okay, so I talked about the aftermath of Hurricane Sandy in the context of mediation. Now I'm going to build on what Christine just shared with you about an example with third-party impartial facilitation. And the first thing I'll focus on this particular item, which was a group of federal agencies. There were 2 federal agencies, the state of New York, and the 2 counties on Long Island. Long Island is just east of New York City, and it has about almost 3 million people. It's a huge island. Those entities came together to form the Hurricane Sandy Smart Growth Resiliency Partnership. They were later joined by a university on Long Island and an NGO, the Nature Conservancy, and some other partners. And their whole purpose was to ensure that rebuilding in the aftermath of the storm happened in a resilient fashion away from flood zones. So they had a common goal, but they struggled for the better part of a year to accomplish anything. And that was in part because, as Christine mentioned, the complexity of the issues. They had their own institutional perspectives. There were political reasons why they couldn't come together. Among others. So they hired a mediator from the Consensus Building Institute, and this mediator helped them to organize themselves, and as a result they ended up having a process established that was started with a kickoff meeting with 100 stakeholders from Long Island representing different interests to identify the projects that were most important to the people of Long Island. And that resulted in some really exciting projects, including development of a scenario planning tool to support communities, ecosystem services valuation, health impact assessment, and a tool to assist communities to shift their planning and zoning that would be climate resilient. One other mention of a post-Sandy event was another facilitation in the little town. It's a very small town on the Hudson River called Piermont. And in that example, the community had $20 million in damages from the storm. And they were facing 6 feet of sea level rise by 2100 and regular flooding in the town, even without a big storm. So they created the Waterfront Resilience Commission, which was facilitated by a professional facilitator, and it resulted in community dialogues. They called them living room conversations, where they got people in the community together to air their views about how to deal with the future effects of climate change. But more than that, they trained local facilitators to carry the work forward and to build capacity within the community and to reimagine their waterfront. The last thing I'll mention, which is on the right of the screen, is a project Mediators Beyond Borders is involved in. It's called Adaptation Without Borders, which was initiated by the Stockholm Environmental Institute, the Overseas Development Institute, and IDRI, and now we have joined along with 9 partners to address transboundary impacts of climate change. Climate change doesn't recognize jurisdictional boundaries. So we have countries that are in geographic locations experiencing similar effects. Likewise, we have cascading effects where a country in one part of the world that perhaps applies rice to a country in another part of the world but has a drought can no longer supply that rice to that country in the other part of the world, which may very well be a developing country. And so there's cascading and bordering climate risks from climate change. One of the things that Adaptation Without Borders is doing is looking at the policy engagement opportunities, which will include dialogue and engagement and collaboration. So Mediators Beyond Borders will be working with Adaptation Without Borders as in that facilitation role to further their work on a whole host of issues, including the global stocktake, the global goal and adaptation, the Hindu Kush Himalaya country collaboration, and also a collaboration in Africa. So I think that's where I'll end it and turn it back to Michael. Thank you.
Thank you very much, Christine and Joe. Also here, you can intervene right away when you want to address a mediation question, because now we go to our third round, and as announced, this is communication. Now it gets broader and broader. And we have the international, as indicated, International Environmental Communication Association with us. And I am happy to introduce to you Miriam Rasukeli, Assistant Professor of Environmental Science in the Department of Environment, Geography and Marine Sciences at Southern Connecticut State University at New Haven. Mrs. Kelly teaching and research focus on the human dimensions of ocean and coastal climate change issues. She completed her Master of Science degree in Organizational Communication from Central Connecticut State University and her doctorate degree in Environmental Science from Oregon State University. And right afterwards, we will have Gregg as a professor in the Department of Speech Communication and adjunct professor of forest resources at Oregon State University. On campus, Gregg teaches courses in conflict management, bargaining and negotiation, mediation, international negotiation, natural resources decisions making, and peace studies. Off campus, Gregg conducts training programs on collaborative decision-making, designs collaborative public participation processes, facilitates collaborative learning community workshops about natural resource and environmental policy issues, and researches community-level collaboration efforts. And he holds a PhD and MA degrees in communication studies from the University of Kansas, and BA degrees in speech communication, sociology, and history of University of Minnesota. So a very broad experience and background in communication and very specific on it. I am happy now that you start your part of our panel, Miriam.
Thank you, Michael. And thank you all for being here this afternoon. Much of my work has really been with the multi-party facilitation that Christine was talking about, as I've worked on coastal communities that are dealing with climate impacts. Many times those impacts are impacting many different people in a lot of different ways. And so for us in our work, it's often about helping those groups build communication competencies that can help them work through their conflicts. And so for us, we see being able to manage conflict and in some cases solve it, and there is a difference there, is very much about communication. And I think it's really important that when you're working with multiple parties, you have to understand that often everybody in the room wants their voices to be heard. They want to say what they think and feel about the issue at hand. But more often, it's really about listening, about listening comprehension, about opening up the dialogue and getting people away from that positionality that they might be bringing to the table and helping them to also build their communication competencies so as to build capacity to work through the conflict at hand. And so many times, people come to the table, they want to send messages, they want what they have to say to be heard, but managing the conflict is more about opening up the space for dialogue. And so, we really believe that the listening process is more important than anything when it comes to managing conflict in terms of communication competencies. And what I'm going to really focus on today, because I am a researcher and someone who has a background in evaluation, is the value of actually assessing the situation that the conflict exists in. And this involves assessing stakeholders, but also other aspects of the conflict that might be inherent that you need to understand as a facilitator to help those parties work through whatever it is they're working through. Some of the key things that we look at or assess when we're looking at a conflict are things like, what are the positions of the parties? What do they care about in their terms of their interests? And then also, what do they need, right? What do they need to get out of this that is going to possibly drive their decision making at the end? And there is no shortage of conflict assessment frameworks or stakeholder assessment frameworks. But really, as a facilitator, it's about choosing the right framework. And oftentimes, too, we get kind of caught up in using this particular framework created by this particular organization. But in my work, I've really found that looking at the frameworks that are available and then drawing in the aspects that are most relevant or related to the conflict at hand is really the best approach. So kind of getting stuck in the vein of just using one framework over and over again is certainly not a good approach, but really thinking about the context of the conflict and what kind of assessment approach is relevant for that. So I've listed here some of the big ones that you might turn to for guidance, especially for those of you who are doing international work. And actually, before I move on to what are those aspects, I made a point about the fact that one of the great things about doing conflict assessment is being able to, at the front end, maybe start to understand whether or not that conflict actually is solvable. Sometimes they are not. And so sometimes as a facilitator, you're not necessarily working with those parties to come to a resolution or a conclusion, but rather you're helping them manage the situation and work through it in that way. And so conflict assessment can be really helpful for understanding the extent to which you actually, as a facilitator, can help negotiate an agreement at the end of the day. Some of the things that you might look at when you're assessing conflict, when I start, I always, as a systems thinker, I can't help but think about the context, right? What is going on outside of the conflict that might be context for how the conflict appears or how the parties in the conflict actually think about the conflict. Another piece is identities and cultural identities too. People hold identities of themselves that when they come into conflict with others, those identities might be threatened. And so seeking to understand individual identities and knowing that that identity is ultimately driving their behavior in the conflict is an important part of the assessment process. We also think about, what are the priorities of the parties? What are the things that matter more than other things? And that is an important piece because then you can start to tune into, what are those big interests that those individuals might have in the conflict system. Another piece of this is that we have to understand that all conflicts, and when we come to the table as facilitators, mediators, arbitrators, litigators, there is a history that exists. And so when we do conflict assessment, sometimes we're looking at what is the history of the conflict in that community or with those parties, and really keeping in mind that, yes, we've arrived at this point in time where maybe the conflict has come to a head and we've been brought in as a facilitator to help manage it, but knowing that there are probably things that have happened in the past that are context for what might happen in the future. As a facilitator, we often are thinking about relationships and the relationships of the parties and how do those interact with one another. And with that comes something that Christine brought up earlier, and this idea of trust. And when you're doing conflict assessment, you're often looking at, do the parties trust each other? Do some parties have trust with each other and some parties don't have trust with each other? What are the levels of trust, right? There's a lot of complexity to trust dynamics that when we're doing conflict assessment, we're taking into account. And because I'm a systems person too, there's procedural aspects of conflicts that exist. It's not just about the substantive issues that are on the table. There are procedural things that need to be understood in order for a facilitator to understand the system within which the conflict is taking place. And so oftentimes we're assessing what is that system, what are the procedures that are in place? Do those procedures have to be the way they are, or is there some ability to kind of change or manipulate those procedures in for the goal of actually managing or resolving the conflict? Of course, as we've been talking about, there are legal aspects and policy aspects. And so as a facilitator, I found that it's very important to understand whether or not, if those parties come to a decision at the end of the day, if it actually is legal for that decision to happen, or if it might have policy implications. And so when doing the assessment process, you kind of have to think about the outcome that may happen and the extent to which the decision might actually be feasible from a legal or policy standpoint. As with many things, sometimes conflicts, actually many times, conflicts have to do with money and financial aspects. And so when we're doing conflict assessment, we might think about what are the financial burdens or what are the financial implications of a decision or set of decisions that might be made, because oftentimes that will have weight on the extent to which the parties want to participate or willing to participate, or the decisions that happen at the end. And then the last point, I think Christine brought this up as well, that we can't understand a conflict situation until we understand the dynamics of power and dominance within the conflict, the parties in that conflict. And also often, we kind of come to these situations with the idea that everybody kind of has the same level playing field, and as a facilitator, that's ultimately what we are trying to achieve. However, we also need to understand going into it, what are the power dynamics? Who might have dominance over others? And because we know that that will affect the communication that those parties have with each other, it affects whether or not people are willing to speak up, whether or not they're willing to agree with a certain outcome. And so power dynamics are incredibly important to understand. So, in the end, I guess, as a researcher and a communicator, I guess I'm positing that the most important thing when we're thinking about conflict is not to just assume things about the nature of that conflict or the stakeholders or the parties that might be involved, but really do diligence and use the resources we have to understand to the best of our ability what the actual dynamics are of the system that is, under decision. And so, I urge you all to consider taking a more research-based approach in your conflict management work. And I'm also happy to answer any questions you might have for me about all of that. And thank you for listening.
Well, as the last speaker on this panel before we get to questions, I'll share with you just a few comments, but I want to start with a question for you. Well, actually a task. I want you to think for a moment about who in your life you think is a really, really good communicator. Think for a moment. Somebody you know or somebody you've watched who is a really, really good communicator. That person is so good at communicating. Now think about that for a moment. And think about it this way. Is that person a good communicator because the person is effective in communicating a message, in influencing people, in getting things done? The likelihood is we will identify someone as a good communicator who is really effective. But I want to challenge you to think about two other aspects. Is the person's communication, action appropriate? Is it ethical? Is it fair? Is it just? If I'm a politician who uses fake news, makes up lies about elections, but I do it in a very charismatic, articulate manner, and I persuade a lot of people to follow me, am I a good communicator? Because my behavior may not be appropriate. And then what about this? What if I go into a situation and I use language that people don't understand? What if I'm a government scientist in the world of climate change and I know more acronyms than anyone? And I use them. I confuse people with LULUCF and CDM and who knows what else. Now I've not adapted. So I want us to think about what we've heard from our panel, whether we're dealing with arbitration, whether we're dealing with mediation, whether we're dealing with facilitation, how important it is that we expect of ourselves and we expect of others to be competent communicators. And the recognition is that competence is something that audiences determine. You'll decide at the end of my few remarks if I'm a reasonably competent or incompetent communicator, based on the few minutes that I've spent sharing ideas with you. And you and I reflect on our own behavior on a regular basis to think about how we are doing as communicators. So competence is something that our audiences or our listeners or our receivers are judging, and we judge certainly in ourselves. And so I want to share with you just a couple of ideas about the importance of competence. And I'm doing that in a couple of different ways. One, to think about competencies related to dialogue and deliberation. Now, I use those terms because I think those terms are an important part of an arbitration process where it's very deliberative, a mediation process where I'd say it's both dialogue and deliberation, and a facilitation process that may emphasize dialogue more than others. But cutting across all of these alternative dispute resolution contexts, obviously, we need to listen actively. That may be something that we might all nod and say, well, that's so obvious, but we don't do it very well. And we can practice being better listeners as part of being competent communicators. We need to be better questioners. We need to ask questions for clarification. And I remember when I was a high school teacher in my 20s, I agonized for about a year whether to go to law school or whether to go to graduate school. There's a part of me, now that I'm in my 70s, still wished I would have gone to law school, although I like being a college professor. And part of the reason is I wanted to learn how to argue better. I wanted to learn how to ask questions better, competencies that we often associate with the legal profession. But I also learned when I went to grad school and studied communication, this importance of monitoring was such a big part of being a good communicator. To be able to be culturally sensitive and responsive, to be able to handle stress in ourselves and in the people we work with, to respect face concerns, and obviously be addressing language issues as well. And there's a broader range of competencies related to dialogue and deliberation, but these are some of them that I found have been particularly acute. But the other area I want to focus on is argument. And I want to once again ask you to do something for me here before I wrap things up. I want you to take just a few seconds to think about a best argument experience you've ever had. Take a minute. Can you think of an argument experience? That was a great experience. I'm glad we had that argument. Now, think for a moment about a worst argument experience. Oh my goodness, I wish I'd never had that argument. That was an awful experience. I'm going to hypothesize that you could think of your worst one quicker than you could your best one. And it's partly why argument kind of gets a bad name. Now, I have friends in the mediation and facilitation community who will say to me, oh no, when I facilitate, I don't want anybody to argue. And I'll say, I want the opposite. I want people to engage in constructive, collaborative argument where our ideas may compete, but we don't have to be competitors. And so when we think about that, this is what I often teach my students. We need to be good advocates. Everyone on this panel is a good advocate. I'm guessing everyone in this room is a good advocate for causes you believe in. And advocacy is part of why we argue. We want to persuade other people to believe what we believe, to act in a particular way, to address the climate crisis in a constructive way, at whatever scale or scope we're considering. But I also want to encourage us to think about argument as a way of knowing, as a way of really coming to understand better the points of view of other parties. And we can think about these negotiations. This is my 13th COP. I've been to over 35 UN meetings, sitting in on negotiations, and they are often painfully slow. And we know that's in part because we have 195 plus countries trying to reach consensus. And they do that in part by working through the arguments for this alternative or this language or that language. But I also found that if we take the approach that part of constructive argument is not just trying to persuade others, but to learn from and with others to explore alternatives. And I'll end with this little story. For the past 30 years, I've designed and facilitated hundreds of community workshops on environmental issues. And as my colleagues, certainly Mariah and Christine and Joe will tell you, we use ground rules, or I call them civility guidelines, for how people are going to interact as part of that process element that Christine talked about. And one of them that I have is be constructively skeptical and argue respectfully. Those are part of my guidelines. I've had people come up to me and say, thank you for encouraging me to raise doubts, to be skeptical, and to be able to argue with one another as we try to make the best decisions. So I leave you with this. Whether we approach arbitration, mediation, or facilitation, let's encourage these dialogue and deliberation skills. Let's encourage these constructive argument skills. Let's encourage critical thinking, and let's encourage people to do their very best to be competent communicators. Thank you.
Yeah, thank you so much. And now we come to the last round. So I come back to my idea that we need a climate arbitration court in the world, and it has apparently we have to integrate these fantastic mediation and communication skills in it. And just an additional word, what we want to offer with this court. Of course, an arbitration court must offer specific procedures like integrating mediation and communication, but we have to be aware that different from public courts, parties want to be clandestine sometimes. We have to offer it, but we hope that we will find parties who say we have nothing to hide. You know, we want to be extremely transparent that our dispute is for the best of climate change. We want to offer that. Of course, we have to offer also fast tracks that you can forget these long standing procedures in the climate courts. And my wish is also, if there's a lawyer among you, if not, I will tell you, these climate arbitration will work on the ground of an applicable national law that the parties have agreed on. But we want to offer them that they can also have a more progressive law applicable. Just one example. When they define a national law, okay, this case will be dealt with according to French law. But if this law is not fully in line with progressive international standards, we want to ask the parties to agree on having the stronger climate law standard. So I think there are many options, and finally we need a court, the climate disputes, not arbitrators that are in investments, in energy. We think the climate law, the climate change science is so complex that we have to offer for these disputes experts in climate science. And now I'm happy if you feel motivated anytime, raise your hand. Otherwise, I would give the word back to the first speakers to think what we are discussing here. What is the specificity of climate policy in communication, in mediation? So, Greta and Maria. Here, this has priority. Excuse me, men first. Yeah. Do we have a mic, or otherwise just come here for your question? Come here. Come here. Very fast. You are fast. Then you are seen like from the world.
Thank you everyone for that really engaging panel. So I read on the on the description for this that you would be getting into hypotheticals on loss and damage. So I want to pose one to see what the panel thinks about it. And this covers the entire gamut of what we heard, so it would be great if the panel as a whole could also respond. I'm from Pakistan, and part of what the flood loss and damage question has been, the focus has all been on international, at that level, at the state level, right? First world nations and their emissions. But on ground, the losses, particularly relating to specific communities, emerge most from the exacerbations posed by structures, infrastructures, that were in fact funded, set in, and policy advised by World Bank, by IMF, by other such international bodies. Some of these have even been subject to inspection, investigation, claims within those bodies, and have been found wanting and liable on those fronts. So they've actually accepted responsibility on certain fronts for a couple of them. I can quote you one example, which is of the left bank outfall drain in Sindh in Pakistan. Now, the problem that we face at the community level, and everything is being covered here, multi-stakeholder issues, issues of the internal structurings, issue of guidelines. The problem is threefold. One, when you petition the World Bank to talk, they impose a set of guidelines on what consultations will amount to and what are the rules that structure them. They're pre-decided. There's no process through which they can develop in the thick of those negotiations, as it were. That's one. How do we deal with that kind of a situation? Number two, when you're talking about dollar figures in loss and damage terms, and there's an acceptance and acknowledgement of some kind of responsibility, but there is no methodology for what the contributory co-causation would amount to in dollar terms. How much of the total damage of the 30 billion figure being cited at this point can be contributorily connected to what the World Bank did or didn't do, what it did or didn't propose, right? So there's no way of reaching a methodology on that. And number three, when you have a situation in which the power dynamics do not seem to be registered by one group, which is in this case the bank, of course, and it is in fact registered very clearly by the other group, which is the communities that recognize themselves as being oppressed, particularly because we're coming out of negotiations with them right now, dialogues if you may, and they feel as if, no, we do not have any kind of obligation, and they feel as if we're already the parties doing good in the world. And you are the parties who are being overly, condemning us, damning us in protests and so on and so forth. How would you all deal with that kind of a situation? Thank you.
Thank you very much. And now first come, first serve. Where's the first hand? We cannot all answer. Who would like to have the word on the floor?
Yeah? No, sorry. Can you just phrase the question? I lost the end part. Like in an infrastructure infrastructure project and with the community?
Yes, I mean communities who want to petition the bank for instance, because their national laws don't permit any kind of movement on this front, and as you can see, the UNFCCC framework doesn't provide one either. That's at the parties and state level. So how would you propose or how would you advise such communities? Of course, you can't give specifics, but I want some general drawing on the principles that you presented today.
Yeah, well, I can speak a little bit about my work in Brazil, and I work with infrastructure projects, big ones like reservoirs and so on. And they are this, we have this difficult part of dealing with the communities, because you have to move them, to dislocate them sometimes. Nowadays, it would be impossible. We don't build reservoirs as we used to do. It's not possible. But sometimes we have to deal with them, and we have to not only, I think that you have to advise them in a way that you need to go beyond the law, the environmental law. Because the environmental law just requires you some conditions, and companies, they say that conditions are too heavy on the project, but sometimes they are not exactly what the communities want to. So I think there is a link between the project, the people from the project, the management from the project, and the communities to organize them and to use maybe facilitation or things that I liked very much when you said sometimes they say something, but they want another thing. And the law is not able to cap that, to get that. Every case will be a case. So maybe the law is just one thing to look at. And then we need more organization from their part, the community part, because they are always in a kind of a disadvantage when they are discussing, because they are not organized, or sometimes they are organized under a government institution that doesn't know exactly what they need to. And it is very common in Brazil with indigenous people, and that's one thing that, although I'm always most of the parts working for the companies, I can say, and I liked what Professor said, you have to bear in mind that the aim is to avoid climate change. The aim is to get a better environment for everyone, for the project and the people. So I think the mediation and communication and skills would help a lot in this thing instead of going to the court. So the project gets stopped, the people doesn't get what they want, and everything gets delayed, and it's just something you cannot do. I'm not so sure if I could answer your question, because it's very difficult to answer, but we are trying to find solutions, and I think communication can help a lot.
Thank you very much. Any more wishes? Yes, please.
Thank you so much for the expose. It was very interesting. And I had a question related to dams. We are facing, especially in Africa, many situations where construction of dams is intended to displace a lot of populations, and there is no way of discussion, of facilitation. And I was wondering, with some cases in Brazil, with the developer Three Gorges, which comes from China, there has been a lot of implications, impacts, and if I don't mistake, floodings also. So do you think arbitration could be a solution, as litigation seems to be very difficult for communities to access? And in case mediation is possible, what do you, Mediator Without Borders, think about that? And in terms of communication, I wanted to know communication facilitation. What is the best way to engage with communities who are afraid of taking the step to fight that, or to go through one of the processes that you have talked about?
Thank you so much. This is perfect, like a last round, that you have addressed all three disciplines. So let us start maybe with law.
Thank you for your question. That's a really interesting question, because as we have so many dams in Brazil, we have to deal with that all the time. And to give you a number, when I was doing my PhD, I did a research, and 70% of all the projects were being discussed in the court. And the same question is always, either companies, they want the conditions to be lower, and displacement is a big thing to consider. That's why Belo Monte, the so controversial dam, was actually built a river, along of the river. It's not, it doesn't have a reservoir because it was impossible to have it there, and I think it's right, because we would have to flood a huge area in the Amazonia. But I would say that the thing is, mediation should be very useful, and they will talk about, and communication, to maybe to settle and to the consultation part, and before the dam is built, you know, during the project phase, like to have an agreement with the people. And maybe arbitration would be afterwards. If something doesn't work in this agreement, then you could elect arbitration to sort it out, some of the questions that might arise, because it is a long-term agreement. You displace people, and it is not only to move them from another place. You have to ensure that they will have life there, proper life, and it will have to be, the company will have to be responsible together with the state for a long time, and things might arise later. But I think mediation, communication can help much earlier, maybe.
I pass on the word to the mediation specialist, and of course communication has the last word.
Joe and I are a team, so we needed to collaborate. I'll say a bit, and then perhaps you could say a bit. I think this is a situation in which civil society could have a big role to do the consultative process that governments might not be doing. Now, I take your point about fear to get involved, but if it could be framed as a sharing of information and assisting the ongoing project by collecting in one report the views of multiple stakeholders, especially needed for successful implementation of aspects. I'd need to know a lot more about the situation to know what the actual angle would be. But that's my first thought, that you can, a body that has been left out can still have an impact on a process if they're providing information that can attract international attention, or could even just mobilize internal resources of citizenry, or even people within the government who perhaps hadn't thought through the implications of all aspects of what's going on. And I don't want to minimize the situation that you're in these situations, but I think that there is a role. And I'd add that also to the question that was asked earlier about, well, what about if the World Bank has pre-listed all the stakeholders? Ultimately, they want a project that works. So even to provide some input from stakeholders not listed, or in the early phases of that, go back to them with, we know you want all the stakeholders, here are some more that may be engaged within the process or in a parallel process. So that's my first thoughts on that.
And now,
Professor, can I just forgot one thing that I think might be useful as well. In Brazil, we have a public consultation process for every project, but it is not enough, because sometimes there is no information and it's just one step. And I worked in a case when we went to the court to question that the consultation wasn't actually being effectively. So it was redone, and we had another opportunity to discuss with some communities. Thank you.
I know the next side event is starting any minute now, so I'll make this brief. That I think part of what I was talking about with the assessment process, it could also be a capacity building process for those who are fearful of getting involved. And so, engaging people in collaborative learning through assessing the nature and extent of the situation can be incredibly valuable for helping to identify areas where they might be able to actually provide their input and participate in that decision-making process. And so it can be incredibly helpful for building what we call self-efficacy or confidence in being able to address the situation collaboratively with people that have already been identified.
Just a quick addition to that, and I think capacity building for the government entity or the agency or the one who's in the position of power as well, because there are examples of governments and institutions that are doing collaborative governance with communities. And so presenting to them examples of that and offering them the opportunity for building their capacity for better stakeholder engagement can help with the structural change that I think you were talking about.
So now it's time to conclude for our online guests, but take advantage of these speakers. Don't let them run away. You can ask them questions now offline. Thank you very much. Outstanding speakers. And thank you very much. You were also a fantastic audience. And yeah, we will see you again next year on the COPE. Thank you.